You've started a lawsuit against the doctor whom you once loved for medical malpractice. And now, shortly after starting your case, the doctor picks up the phone and calls you. Do you have to answer the call? Do you have to talk to the doctor when he calls you? Would you like to know the answer? Come join me for a walk near the beach as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The answer is no, you don't have to talk to the doctor. First of all, it's going to be highly unusual that the doctor whom you have sued is going to pick up the phone and call you after learning that he has been sued. Once in a blue moon, and I can tell you this has happened to my clients maybe once or twice over the course of 34 years that I've been in practice. If they do somehow pick up the phone to call you, do you have to answer the phone? The answer is no, you don't. You can let it go to voicemail. So what happens now if the doctor calls, you pick up the phone and you answer it, and it turns out it's the doctor whom you loved. You trusted him. You put your life in his hands. And now he calls you and you say, hey, Mr. Jones, it's Dr. Gonzalez. I just want to ask you a couple of questions. I understand you just sued me. Can I ask you why? Do you have to answer his question? What do you say in response to that? I'll tell you what you say. You say, doctor, I'm sorry, but I can't talk to you. If you have any questions, please have your attorney call my lawyer and they'll be happy to talk to each other. My attorney will be happy to talk for me. I don't feel comfortable talking with you and I'd appreciate if you don't call me anymore. That's it. That's all you have to say. Nothing further. You're polite and you're telling him, I'm sorry I can't talk to you and I don't wish to talk to you any further. That's it. Now, what happens if the doctor continues to talk despite the fact that you have not hung up the phone? Despite the fact that you have told him you don't want to talk to him anymore? If the doctor says, listen, I just want to apologize. Now you're listening, you're intent, you're hoping that he continues on with this line of conversation. You want to hear him say, I'm so sorry for what happened, it never should have happened. Is that going to happen? In my experience, the answer is absolutely not. There might be an instance where the doctor says, listen, I'm sorry for what you had to go through. I understand that you had this complication, but it's nothing that I did that caused or contributed to your injury. In that instance, what do? Say, doctor, I'm sorry, but I can't talk to you. Have a great day. In that instance, you have to end the conversation. You don't want to continue that conversation because the longer you stay on that call, the longer you risk revealing certain information about your motivation, about the problems you're having, about certain things that he may have done or not done or said in the past, and you don't want to go there. Simply and firmly say, doctor, if you have anything else to tell me, please do so through your attorney, and they'll be happy to talk to my attorney. And that's it. You're under no obligation to talk to the doctor. Don't be concerned or worried about what effect that's going to have. However, if the doctor does in fact reach out to you to try and ask you questions about why you sued him, you should notify your attorney about that because your attorney will want to know that the doctor reached out. And your attorney will ask you questions about what the doctor said and what questions he was asking. Now, why is that important? It's important because during the course of your lawsuit, your attorney will have an opportunity to go ahead and ask the doctor many, many questions about what he did and why. And what we call a collateral attack. Your attorney will ask the doctor questions about whether he actually called you after the lawsuit was started. And then he will probe to see what questions or what the conversation entailed, what are the details of the conversation that he had with you. And if he denies having this conversation, now he has created a factual conflict, a question of fact about whether or not this conversation actually took place. And many times that can actually benefit you and your case. Why? Because now it establishes a question of fact. You claim that the doctor did in fact call you and you remember the specific details of your conversation. The doctor now denies months later that he had this conversation and denies the questions that he asked you. Now, why is that important? Because even further down the road, at the very end of your case or toward the end, when your attorney notifies the court that all discovery is complete, the defense oftentimes tries to get your case thrown out by making what's called a motion for summary judgment. They say, Judge, there are no questions of fact in this case. And because of that, there are only questions of law that we want you to act upon. And there's no need to go to trial to get these answers. That as a matter of law, this case should be dismissed. And you and your attorney say, wait, hold on a second. There are clear questions of fact. My client said A, B, and C that this conversation took place. The doctor says, no, it didn't. That, in and of itself, is a question of fact. It's a different matter whether or not that is a material question of fact, meaning, does it have any bearing on whether or not there was malpractice here? Does it have any bearing on what injuries you suffered? If it doesn't, that's really not going to help you. But if it does, now it may help you prevent your case from being thrown out later on toward the end of your case. So why do I share this great information with you? I share it with you just to open your eyes and to help you understand how these types of cases work in the state of New York. You know, I realize you're likely watching this because you want to see the gorgeous scenery. No, I realize you're watching this because you likely have questions or concerns about your own matter. Well, if your matter did happen in New York, and you're thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I hope you have a great day.